It's indeed an honor to address all of you. And I must thank Dr. Professor T.R. Subramania sir for giving me this opportunity, and also Dr. Badalmati, who approached me and facilitated this entire event. And I must thank CMR University of Law School also for giving me this opportunity. Uh, I also must thank, I also must congratulate the center for taking up this initiative and to make the most of this pandemic situation, and by imparting all different fields of knowledge to help the students to reach to them, and then to take the benefit of this period. This is indeed I must say that this is an opportunity for students to get various kinds of knowledge and experiences, and the anecdotes. You will get so much of knowledge. It's everything is, at the tip of your finger now, and it has become much more rich now. The resources are much more rich in the internet because of the pandemic. So the center is making the most of it, and I congratulate the center also for this, for taking up these activities. So without much delay, I will go on to the subject. So the realization of gender justice practical challenges, that's the topic I have decided to talk upon. So I'll start with one curious quote I came across with, which also I strongly believe in. So Lucy Stone, US orator, said, I'm quoting her, "Too much has already been said and written about women's sphere. Leave women then to find their own spheres." So this, she said in 1800. We have seen many things have been written about how wonderful women as mothers, how awesome are women as daughters, friends, sisters. We've been teachers, bankers. There have been several set standards by scriptures, by religions, by rituals, by elders, by practice, by cultures. So many things have been written, said, addressed as to how women are or women should be, right? So it's time has come to leave the women to their own freedom, and for them to pursue whatever they want. Unfortunately, this what she has said in 1800s is still relevant. We are in 21st century, and then this is the situation. So talking about gender realization, say gender justice, because how the society, because of the very complex nature of the society, because of the historical events that had taken place. I'm speaking in the context of India only. So historical events that had taken place, because of the political game, the power play. In the time of independence, 1947, we had become a society, or we had become a nation which treats generally women different than men. Of course, among women, there were several other groups with respect to different castes, different class. These are all intersectional problems that is there. I acknowledge that problem. Yet, generally, women were largely treated differently than men at the 1947 time. So we had to start afresh as a nation. In legal sense, we had the opportunity to start everything afresh. But then the same was not the case with the society. We had to deal with the society as it was, right? At the one night, we couldn't have changed the society with all its limitations. So we definitely had challenges. Yet with those challenges, the project of gender justice has been definitely been one of the projects which have been undertaken by our constitutional framers, I say. So that project was undertaken and have been slowly progressing, I say. It's not very rapidly. Of course, the stable changes take place gradually. So the changes have been taking place. Yet even today, there are challenges which we face. So I'm talking about those practical challenges which we come across when we are when we are walking towards the direction of gender justice. So I'm limiting my talk or my exercise to explore the challenges, practical challenges in litigation, since that is of much value to you from an insider or from a person who's working on those aspects on a daily basis. So I'm not going into the political, social, or public dimensions of this gender justice aspects. So I'm limiting myself to the litigation part of it. So the challenges are so many, as many as are then in number, that I have to categorize and subcategorize, So I've broadly classified into two categories. One are the personal challenges, and the other one is challenges that are attached to the cause. So the personal challenges, if I'm speaking about, uh, the challenges which you have to face on your personal level because of your identity. So if you are a woman lawyer, if you are a male lawyer, so the challenges which you have to come across, those are, I call it as personal challenges. So if you are a woman lawyer, at first, I'm sorry for the disturbance. I'm audible, right? I'm audible?
Yeah, you're audible. Continue.
Okay. So uh, if you're a woman lawyer, at the first blush, you might be taken as a sincere, diligent, meek, or soft lawyer, if I may call, unless you have put up your image as an aggressive lawyer, or as a vocal, or as a revolutionary, as a woke lawyer, unless you put up that image of yourself by being loud in your submissions, or by being very aggressive in your nature, or by very appearance of yourself, unless you put up yourself as someone who is not ready to take any other what you say any other subservient kind of nature, you will be treated, or you will be taken as the soft lawyer. So consequently, what happens is there will be like two groups of lawyers, women lawyers. One is soft kind of lawyers, and the other aggressive kind of women lawyers. So if you're a person who don't want to belong to either of your identities, or either of your groups, if you want to strike balance between these two, then you will have to face a lot of challenges. So these extremes groups have become because of this taking behavior as prejudice, with a prejudice mindset. And at the same time, even if you are a male lawyer, of course that also comes with the prejudice. So if you are setting a standard, behavioral standard for one group among two, then consequently, or by without unconsciously, you are prescribing behavioral standards to other groups as well. See, the male lawyers will be facing the challenges if you are not manly enough, they call, or if you are expressing the traits which are labeled as feminine, if you are not very aggressive, or if you are not headstrong going with your decisions, if you're soft. So these behavioral challenges even the male lawyers will have to face. I'm not going much into details for this personal challenges, because everyone has their own ways of getting over with it. And the larger societal behavior, or societal, what you can call the societal reformation, also will have an effect on this. So I will move ahead to the challenges that are attached to the causes. The cause, I mean gender justice. So challenges that are attached to causes can also be subcategorized. I've broadly categorized into two groups. The first one, I call it as the established concepts of law in respective fields. The very established concepts of law operate as hurdles to the realization of gender justice in many a times. That is one, I'm explaining it. And the other one is institutional challenges. The very judiciary, or the fraternity, inclusive of lawyers, judges, clerks, bench clerks, registry, and everything, institutionally, they pose certain challenges that also we will briefly talk about. So the first one, the established concept of law in respective fields, if I'm talking about, the very concepts, people might have heard, you might have heard as law for men, law is for men, right? So because of the predominance of male gender in the society, many a times lawmakers have been male members of the society. So the law is predominantly, sometimes even unconsciously, is designed as per the convenience of the male dominated society. So that you might have heard, that has definitely affected the concepts of law as well. So that will act as a hurdle to when we are talking about realizing the gender justice. So first we'll talk about Joseph Shine. If I'm talking about particular, with my individual experiences with each cases, this concept may become clear. So I'll talk about Joseph Shine versus Union of India. You must be aware of the case. Section 497 was struck down by the Supreme Court of India. So the most convoluted provision ever I have come across in my litigation life, I would say, Section 497. It was indeed very interesting to work on that case. So the woman is punished if she is getting into sexual intercourse with another man who's not her husband without the consent or connivance of that her husband. That man will be punished. So that's the provision. So it is wrong in many levels. So the prejudice or the discrimination, set of discrimination which women faced with the provision was that the first one was she was literally treated as a property in the provision, because the consent and connivance of the husband which was required for her to have sexual intercourse with another man to whom she is not married. And then the second one is her privacy, the sexual privacy in particular, to decide whom to have, her sexual freedom was restricted in a way. And then the third one is married women were put to special prejudice. The unmarried women were not having this hurdle. Unmarried women had to take the consent or convenience of her husband if she wanted to have sexual intercourse with other man. And then the men had actually a direct discrimination, because even in the case of consensual acts, only man is punished. So this was the provision. And here actually the concept is that the concept which we had to call the established concept, or the position of law which we had to face majorly, was if you're talking about women rights, women are being discriminated and everything. Women are actually not actually prejudiced. They are not put to actual prejudice, right? They are not put into prison. So what, in any case you go before the court, you can't simply talk about laws in general. You can't speak about what you say, the principles in vacuum. You will have to connect it to the prejudice which are being caused, right? So if you are talking about rights of women, then you had to establish the connection between the deprivation of rights and the actual prejudice caused. But for women, the provision did not actually cause prejudice. It's actually to the men which caused prejudice. So it was a public investigation. There was no requirement of establishing a personal prejudice caused. That was there. However, this issue had to be addressed. So we argued with the help of authorities that the state, by even when state is expressing itself through laws, even in that expression, you cannot the state will have to abide by the principles of equality. That was the argument. So state will, in its expressive it's called as expressive function of law. So even while the expression, even the way the concept is put up in the law, that the about a person or about an institution, even in that very expression, it has to be the state has to abide by the principles of equality. That was the argument which we had taken. So for example, in the particular case, the law had actually treated women as someone who is not capable of being treated, who's not capable of having her own sexual freedom, or having her own capacity to decide for herself. Only with the consent of her husband she could do it. So that was the argument taken. And now you know the history that for section 497 has been struck down. So if someone is telling now that, okay, this provision is not actually causing prejudice to you, then you have a precedent. Now you can cite Joseph Shine versus Union of India now. Then there are several provisions like that. Actually, a curious provision which I had actually come across is section 62 of CPC. Section 62 of CPC actually speaks about the seizure of the properties as part of executions. So the CPC, the section actually speaks in the clause 1. It says that one should not go and seize the property, seize the property if the property is dwelling house after sunset, before sunrise. Clearly reasonable, because one cannot expect the other person to become roofless in the midnight. So that's clearly understandable. And then the second provision says that if the person is inside the home and if he's refusing to enter the home, then you can break open the door. I mean, the officer who is in charge of execution can break open the door. That is the second clause. And the third clause is a very interesting clause. I will read the clause as it is. Where a room in a dwelling house is in the actual occupancy of a woman who, according to the customs of the country, does not appear in public, the person executing the process shall give notice to such woman that she is at liberty to withdraw, and after allowing reasonable time for her to withdraw and giving reasonable facility for withdrawing, he may enter such room for the purpose of seizing the property, using at the same time every precaution consistent with these provisions to prevent clandestine removal. So the interpretation of the customs of country is entirely a different gamut of discussion. I'm not going into that discussion. However, the problem here is, though actually women are not put to actual prejudice here, but the very fact that the statute is recognizing a custom which does not allow women to appear in public, right? So that is there in statute book. So even if you're talking about the constitutional right of freedom of religion, freedom of culture, to practice your culture, etc., etc., overlapping between that right and a right of an individual woman who want to appear in public, that is another discussion. But I'm saying, as a statute, as a secular law, CPC is recognizing a custom which does not allow the women to appear in public, or the women who practice this custom, and that's been acknowledged in the statute book. That is definitely problematic to me. So this is actually you can find several provisions like this in CPC. In fact, there will be several, not only CPC, in many laws there won't be any actual prejudice, but nevertheless these statutes in order to protect women, treating women as incapable of protecting themselves. So that is one concept. And then I'm giving an example of a service case which I had worked on. So there, actually, the lady, my applicant, had taken maternity leave amidst of her master studies. So after master studies, after completing all the exams, after clearing all the exams, she had applied to a notification which prescribed 3 years experience of masters. 3 years experience was the prescribed period of experience in the notification. So what had happened, because of the 12 months leave, maternity leave she had taken, there was a shortage of 1 month for this 3 years to complete at the last date of application. So going by the notification, she was not qualified and she was not included in the rank list. So that was under challenge. So here we know that, the rights of the women who are pregnant women, the rights of pregnant women, and then you must be aware of Maternity Benefits Act. Then you will have a set of labor laws which are giving rights, several benefits to people, women who are undergoing maternity period. And then you also have provisions or case laws where the students who are not able to attend the college or universities because of the maternity leave, and are allowed to appear in examinations. With all these precedents, international conventions, statutes, she was not able to she was not selected in the rank list only because she was falling short of 1 month because of the maternity leave she had taken. So here, what we had to challenge, what we had to face, was the question that there is a administrative law, there is this principle, that's an established principle, that notification, the conditions of the notifications will have to be abide by, no matter what is the condition, no matter the, unless it is challenged and set aside by the court of law, you will have to go by the notification. When you apply to a job, all the terms and conditions of the notification will have to be fulfilled, and there is no exception for that. So that is the settled principle of law. So you had to combat that principle. In that case, then the judge also asked a specific question. So when this is the situation, you had to go by the notification, and then you could have, and then pregnancy is a matter of choice. That was the question also. You were a medical student. You knew that you will have to complete the masters in this period, and then you will have to you might come across the notifications which prescribe this experience. If you are not finishing the course within time, it is your choice. That's the choice you have made. So you cannot be blaming that the government is not giving me my fundamental rights. That was the argument. But then that was met with an argument that there was an American case also, which I relied on, which basically stated that you can choose if the pregnancy is yours, right? If you want to be pregnant or not is up to you. Like, you can control. These days it's not that you cannot control, but then you being born as a woman is not your choice. You cannot decide whether you want to be born as man or whether you want to be born as woman. So that is a choice which is, you cannot make that choice. That is out of your control. And once when you are born as woman, it is not only the conscious choice, it might be also bodily response, the natural bodily response, that you want to become mother. You want to pursue that natural instinct of yours. So if you want to pursue your natural instinct, which comes with your body, over which you don't have control, whether for that, can you be deprived of any opportunity such as employment or any other opportunity? So that was the argument which was made. That argument was well received. However, even with that, there's another concept of administrative law which came in way, is that now, okay, 1 month short of notice considered, agreed, you are being given the right to apply and you're being selected. What if one woman comes with 2 months short of notice, I mean, sure, 2 months short of experience, and then after her, what if some other woman comes who's having 1 year? What is the qualitative difference between the person who is choosing to become pregnant at 2020 and who's choosing to become pregnant at 2021? What is the qualitative difference among those two? So this administrative law, what you say, a theory which came in hurdle, and that case was actually that we did not win the case. Why I'm citing this case as an example? Because two aspects. One is that you will have to be experts in that respective law as well. Even if you are a person who is fighting for gender justice, if you are fighting a service case, you will have to know the know-hows of service case. Or if you are a constitutional lawyer, you should be thorough with the constitutional law practice. So if you are a criminal lawyer, you will have to be conversant with those minute aspects as well. So this however, it was the client was also actually because of her personal reasons, she was not willing to go ahead with the appeal. But even now, I strongly believe that that was a case worth winning, because there was a merit in that case. But it's also, you will also have to know that, it's not one case or one, the what you say, one case or two case you're winning or losing in this path of realization of gender justice. It's a process, it's a never-ending process, it's a journey which is worth of. So that's also the reason why I mentioned this case, even though we did not win that case as such. And then the other case I want to mention is that one rape victim. She had been raped by several persons at the instigation of her stepmother for money, and at when she was at the age of 12 or 13 maybe. And then she had to undergo that the entire this process of her mother being her mother soliciting her and all for 1 year, 1.5 years. And later she ran away from home. She gave the police complaint with the help of an NGO and her original father. She stayed away from home. She came out of home. She stayed with the shelter home, and then she gave the complaint. She studied further. She became, now major. But then the complaint which she had given in the year 2008 was still pending. After she graduated, after she was searching for job, the case was still pending. And she came to me with this with this I had not actually, that was the first time actually I came across this angle. I had not thought about this angle till then. So she came across to me and said that this case is pending from 2008 to 2019, when till she came, 2020 till she came. So she said that she had to remember, she could not forget the days and the time, the trauma which she wanted to forget in her life. Why? Because the trial had not been completed, and she had to remember each and minute details to witness, to depose the witness, to depose as the witness before the court. So every time she goes with the posting date to the court, she had to remember, she had to recollect, she had even written down as to what had happened, so that she can't forget, right? So that she doesn't forget. So she had to remember each and every minute detail of those incidents which she wanted to forget in her life. So with that complaint, or with that grievance, she came to me. There I realized that we are working in an adversarial system, right? So in an adversarial system, we have this concept of he is innocent until proven guilty, right? So all accused persons are given all the opportunities that are possible to prove his innocence. So there are several procedural lacks that may come in because of the human errors, or that several leeway that lawyers can mend. So what used to happen, there were 13 or 14 accused persons. So one or the other will go to the high court at the different stages of case or investigation or any other like procedures, and then they would take a stay of FIR. There was a stay, then of a trial there was a stay. Twice the stay was vacated, and then again there was another accused who went on and get the entire trial stayed. So there were several so the lawyers of these all accused people, who are of course, who are whose ethics is to protect the interest of their clients, took the maximum of these loopholes, or I don't even call loopholes, these are the provisions which are given to ensure the innocence of accused persons. Those were taken benefit of, and then the case was dragged for almost 12 years. then what had to be done, and rather going on on rhetorics, what I did was a small, very small act. I sought for speedy disposal of the trial, putting the light on the victim's side, that she had to remember everything. It is not only the accused who is actually be benefited of speedy trial, it is also the victim who will be benefited out of speedy trial. So the justice delayed, justice denied is not only for the accused but also for the victim. So I was trying to portray the victim side of misery she was undergoing because of the delay which was going on in the trial. By God's grace, I would say, there was judgment to finish the trial within 6 months, and then the accused persons were all convicted also. But then there again comes the appeal. Appeal provision is there, and usually, in because it's a statutory appeal, so the courts tend to give automatic admission. It was given, and courts tend to give automatic stay of the judgment. That is how it is, the criminal law practice. So that is now has been given. So again there is a stall, again there is stall of the proceedings. But at least to a relief that she does not have to personally involved in the case, because she has also already deposed and all the witnesses have been given. But yet, if she is waiting to see that offenders, of her offenders should be punished, she'll have to wait now, or else she'll have to engage another lawyer or engage another person to go behind it and to fight for her rights. Because the government pleaders, unless and until it's a very sensational case like Nirbhaya or some other case which we come across, they don't tend to, it's not possible also maybe to give individual attention, or they don't tend to give individual attention to each these cases of women who don't have voice because of the class or caste, or even not even ignorance maybe. So the government pleaders do not go and pursue those appeals to get it disposed. They don't show the, they don't go on toes, on their toes, to get this matter disposed of. So these files are stacked there. So this is another angle of it. And then there are civil cases. There are civil cases where you have you might be aware of the recent judgment in 2020, where this Supreme Court said that the women are Hindu women are entitled to equal shares, unless if it is not undivided. Doesn't matter if the father is alive or dead, that judgment. So there also, whatever may be the amendment, whatever may be the judgments, in each individual cases, there will be several civil civil law principles which come in your way, to your realize to your rights. Those will have to be fought. There will be several, like delay might be there, adverse possession might be there, or sleeping over rights there. So there are so many principles, or sometime the prescription, the schedule might not be properly described. There will be so many practical aspects, right? You draft the entire plaint beautifully, but then the schedule which is there in the prescription, you have not properly described the property, then the plaint fails. Doesn't matter if you have quoted Supreme Court cases, or doesn't matter if you are, beautifully put all the arguments, you have conducted the case also with all elegance. So this is about the civil case. So these are, I've explored several, I've explored now 4 dimensions of practice: constitutional law, how the principles come in your way, legal principles come in your way, and then the administrative law, and then the criminal law, and then also civil law to an extent. So these are, if we see, this is how we'll have to deal with the established principles in each field, for which we will have to equip in that particular field. So along with your awareness about gender rights, awareness of, what you can say, the women rights and everything, you will also have to be well versed with the respective branches of law where you are trying to or planning to fight on. Going to the institutional challenges, there are ample data available in internet or in newspaper or in research papers how the institution itself has to see a lot of changes yet. If you compare the number of judges, women judges with male judges, if you compare women lawyers, number of women lawyers with male lawyers. Even in Kerala High Court, where I'm practicing, there are only two designated women lawyers, only two designated women lawyers, as against some 40 to 50 male designated women lawyers. That is such a disparity, 10 times, 15, 10 times, 12 times disparity is there. And this is from a state where there is 100% literacy. I'm not speaking about other places where, the women are not even allowed to go to school. So this is there is this and then of course there is entirely a different task set for women lawyers when you go in the registry, when you face the bench clerks, the way they behave and everything. So that institutional challenges, the facilities available in those courts, the very environment, if you don't have women lawyers around, if you don't have women judges around, and if you are talking about gender sensitization, gender rights, you will have to deal in different manner. You will have to, if the judge who is a woman in front of you, I'm not saying the men judges or male judges are not accommodative. That's not I'm saying. That's not what I'm saying. I'm saying the very environment will become different when you are the only person, when you are the only woman surrounded by male lawyers and judges, and you are speaking for your rights. So the entirely you will have to take up different arguments in a different way. So those institutional challenges we are still facing, and there's long way to go to reform those institutional challenges. So this was about the practical challenges. I've not gone to much of the cases because I wanted to specifically pick certain cases from certain dimensions or certain areas of law, so that I can explore those in detail. So this gender justice is not one project or one it's not something which we are finishing with this generation. Or then I've seen people saying that now everything has changed, now everything is changing, women are given everything, women are given so much. In fact, there is a reverse discrimination. I've heard people saying this, but that is entirely it's untrue, or I would say it's complete. There might be some women who are privileged because of other social aspects like caste and class and everything, but then that is not it's not finished. So this is a process which we have been taking from generations, we will have to take for generations. So with these words, I would like to conclude my talk. I'm grateful for patient hearing. I hope I made sense.